My name is Michael David. I was sworn in April of 1989 and departed in January of 2015. I left the bench to do mediations and arbitrations. I'm very grateful for the opportunity to have served as a judge, but bottom line, I thought our role was to provide service to our community, and that included the lawyers that practiced in front of us and the citizens. And so my philosophy was, how do I provide the best service I can? And that service really is kind of a fair handling of the matters brought before me. Most people are caught up in a legal proceeding which they do not understand, sometimes believe that the deck is stacked against them. So to the extent that the judge can portray him or herself as even-handed and fair, listening to all sides, and being calm, I think that just furthers that. I think that's the ultimate benefit from sound temperament. You have to make special efforts to interface with and interact with your colleagues, but I remember countless discussions on, what would be the best practice to do? How could we do this better? What do you think about this? If there's a new idea, what are the pluses and minuses of it? Trying to figure out what would be the best way to handle it. My opinion wasn't the sole governing opinion. I mean, as my father pointed out with me growing up, I could be wrong, even if I thought I was right. So I always valued the insights of all my colleagues. I always wanted to see what the pluses and minuses were. I take that in large part from my experience in the legislature. We used to talk with each other and cross party lines and try to figure out, if there was a solution to a disagreement, and rather than beating heads together. And quite frankly, we learned things, and we did accomplish some of those, some resolutions on matters. And I believe that's what we did here on the court. Probably the most significant case that I handled involved a significant number of hospitals throughout Missouri who sued basically the tobacco industry for compensation for care that they provided to people who had tobacco-related illnesses and who did not have any means of paying their bill. There were interesting legal issues in that case, but also just the logistics. The life of that case was many months, could have been longer. An example is the jury was deliberating for 7 days before returning a verdict. Selecting a jury was a major challenge because you had potential for bias, prejudice for or against hospitals, and also as against the tobacco industry. You also had questions of how many citizens can serve as long as this case was going to take. That was probably the most challenging case that I ever handled. Some of the things that judges have to do are not pretty. Giving someone life in the penitentiary without the possibility of probation and parole is not a pretty thing, but that's what the job does entail at some point. But you don't have to do it meanly. You can do it respectfully and calmly, and even if the person receiving it doesn't see the distinction, others in the courtroom very well may. You hope they do. No young lawyer starts with 20 years experience. No young judge starts with 20 years experience. And what you're looking for is someone who shows temperament and shows a willingness to buckle down and do the job, and who is not afraid to say, either directly or indirectly, I don't know this stuff. You have to teach me. As a trial judge, you are, by definition, a jack of all trades, which sometimes includes, that means a master of none. Take advice graciously, Don't think you have to act like you know everything, because nobody believes you do. Only most of the time they won't tell you that to your face. You know, they talk about one bad apple can spoil the whole barrel or the whole bushel. Well, I didn't want to be that bad apple. I wanted to be one of the good ones. And so I thought every day that I interfaced with people, that my demeanor, my conduct, all reflected on the judiciary.